This is part 2 of chapter 18 under CrPC 1973, Trial Before a Court of Session. We are going to cover section 225, 26 and 27. We have already learned all this section through a trick. The public prosecutor does the opening and on opening the court can discharge the case. Let's cover it in detail. This clip is used purely for educational purpose. Intention is not to offend anyone. Imagine this as court of session. Court of session. Obviously, this is chapter number 18. Trial before court of session. The first section is section 225. It says trial to be conducted by public prosecutor. In detail, it also says the same thing. In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. So I don't need to explain anything in it, but you have to remember that prosecution shall be conducted by a public prosecutor. So in court of session, the first section is 225 and the second one is 226. Section 226 says opening case for prosecution. Let's cover this in detail. Section 226, opening case for prosecution. It says when the accused appears or is brought before the court. Now the difference between the two is either the accused appears by himself. Yes, something like this, or is brought before the court. I hope now you understand the difference between the two, when the accused appears or is brought before the court. The section further says, in pursuance of a commitment of the case under section 209. Now I hope everyone remembers that 209 is regarding a magistrate committing a case to the court of session because it is exclusively triable by the court of session. Even if you don't remember this section, I hope now you remember under section 226, when the case is opened in reference to a case committed to it under section 209. Got it? Let's check what it says further. The prosecutor shall open his case by describing the charge brought against the accused. Okay, the first thing the prosecutor does is he explains under what charge the accused is asked to appear before the court and stating by what evidence he proposes to prove the guilt of the accused. After explaining under what charge the accused is brought before the court, he has to provide list of evidence by which he can prove that the accused is guilty of the offense under which he is charged. Let's take up an case. Hukum Singh versus State of Rajasthan, 2001, Criminal Law Journal 511, Supreme Court. Under this case, the Supreme Court held that under section 226, the public prosecutor has to state what evidence he proposes to adduce for proving the guilt of the accused. It is very obvious public prosecutor is from the prosecution side. If he knew at that stage that itself that certain persons cited by the investigating agency as witnesses might not support the prosecution case, he is at liberty to state before the court that fact. See what happens when the investigation agency, whether it's police, CBI or any other person, any other department has brought the case before the court. There are number of witnesses attached with the case. So it is the public prosecutor, if he considers that these witnesses will not support the case, he will inform the court. This is what it is mentioned over here. Further it says, alternatively he can wait further and obtain direct information about the version which any particular witness might speak in court. Now this is what happen is like public prosecutor will be discussing with the investigation agency that which evidences will come up, will support the case. For that he can wait to start the proceedings before the court till his witnesses are ready. It further says if that version is not in support of prosecution case, it would be unreasonable to insist on the public prosecutor to examine those persons as witnesses for prosecution. Now the investigation agency, which may be the police, CBI or any other department, brings large number of witnesses, it will not be reasonable that public prosecutor should examine every witnesses, because every witness is not going to support the case. In this case, Supreme Court further explained that if there are too many witnesses on same point, the public prosecutor, the PP, is at liberty to choose which evidences he has to consider. Why this liberty is given to public prosecutor? Because it is expected to produce evidence in support of the prosecution, not in derogation of the prosecution case. Now let's check this example again. The opening of the case, the trial, to be conducted by public prosecutor. For example purpose, this is Akshay Kumar, public prosecutor in this case. Everyone has seen the movie and everyone knows that he is trying to show the evidence he has, but only law student or an advocate understands that under section 226 of CrPC 1973, the public prosecutor has to state by what evidence he proposes to prove the guilt of the accused. After covering section 225, 226 and now we come to section number 227, that is discharge. Let's cover it in detail. The public prosecutor under section 225 does the opening under section 226 and under 227 the court can discharge. How? Let's cover it up. If upon consideration of the record of the case and the documents submitted therewith. So the first thing which we see is the court will consider the records of the case and the documents which are submitted at court of session. The second thing it says, and after hearing the submissions of the accused and the prosecution in this behalf. Means the second thing, obviously he will hear the accused and the prosecution, both of them, and after giving a hearing to both of them, if the judge considered that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. I would like to stress on the last line again, he shall discharge the accused. Okay, he thinks there is no sufficient ground to proceed, he shall discharge the accused. But the most important thing is, he has to record his reasons for doing so. I hope you understood the section 227. Let's take up another case. TV Sarma versus R. Mehria and others. AIR 1980 AP 219. In this case, full bench of Andhra Pradesh High Court examined the scope of section 227. It is clear that session judge is bound to discharge the accused if he considers that there is no sufficient ground for proceedings against the accused. The language of this section is wide enough to include any ground which he considers sufficient for not proceeding against the accused. So it is little bit explaining the scope of section 227 that not on specific ground, on any ground the magistrate can discharge the case. Let's check another case. Ramdev versus State of Rajasthan, 1994 Criminal Law Journal NOC 173 RAJ. In this case, it was held that the court is not expected to give detailed reasoning at this stage, but the order by itself must inspire confidence that the record of the case and documents have been duly considered by the trial court, because this consideration may either lead to the discharge or framing of the charge. Therefore, consideration of the relevant record of the case and the documents is a sine qua non for the purpose of framing of the charge. So in this case, the court explained that a detailed reasoning is not required by the magistrate when he discharged the case. If the judge has checked all the documents which are relevant to do so, to take the decision that the case can be discharged, it is sufficient. Now do a little homework. What is the meaning of sine qua non? Write down in the comments. Let me know. I want you to be active. Before I come back, one little request. Respect elders, love kids, make this place a better place to live.